A quorum being present, the subcommittee will come to order. Good morning to each of you and welcome to all of our guests this morning. I'd like to thank our witnesses for joining us today to discuss the costs and consequences of the administration's overtime proposal. Just over a month ago, this subcommittee convened to discuss the need to modernize the confusing and outdated regulations implementing federal wage and hour standards. At the time, the administration had not yet released its overtime proposal, but several of our witnesses were already worried about what the proposal would look like and the consequences for workers and job creators. Recognizing this administration's propensity for executive overreach, I shared many of those same concerns. But I was still hopeful that somehow this time might be different, that somehow the administration would listen to all of the concerns, consider all of the data, and put forward a proposal that would help do some good without doing any harm. As it turns out, the optimism was misguided, much like the rule the administration eventually proposed. In the weeks since the administration unveiled its overtime proposal, even more concerns have been raised about the impact it would have on both employees and employers. Various studies and analyses have shown the administration's plan would result in billions of new costs for employers annually, a reality that is tough for many employers in this economy, but even tougher on small businesses and nonprofits. Unfortunately, the proposal's anticipated consequences extend far beyond added costs and could have much more serious implications for many Americans. Of all the concerns we've heard about this proposal, the ones I find most alarming are those that will limit flexibility and opportunity in the workplace. As employers struggle to cope with the added costs of these new overtime rules, many salaried employees will be demoted to hourly workers with lower pay and stricter schedules. With that shift comes fewer opportunities for on-the-job training, talent development, and managerial experience, all of which leads to fewer opportunities to advance up the economic ladder. And isn't that what America's about? One of the most inspiring things about the American workforce is that a crew member at a fast food restaurant can work hard, earn a spot in management, and eventually go on to become a leader at a major U.S. business. That's the American dream, one that all policymakers should work to encourage, not stifle. I'm sure Mr. Williams will have more to say on that topic. Unfortunately, if the administration's proposal has the effect many anticipate it will, stories like that of Mr. Williams will be harder to come by. Inasmuch as the administration's proposal is flawed for what it would do, it's equally disappointing in what it doesn't do. It doesn't address the complexity of current regulations, and it doesn't reduce unnecessary litigation. As Chairman Klein and I said when the proposal was first unveiled, it's a missed opportunity. What we need instead, and what the American people deserve, is a balanced approach that will strengthen employee safeguards, eliminate employer confusion and uncertainty, and encourage growth and prosperity for those working hard to make a living. From what we've heard so far, the administration's proposal is not that approach. This committee has held numerous hearings and explored various efforts over the years to improve the rules and regulations guiding federal wage and hour standards. We've heard from employees and employers alike that the current system is too complex, burdensome, and outdated. And we've seen studies that show related litigation is on the rise. For all these reasons, we'll continue to urge the administration to improve these rules and regulations responsibly and in a way that doesn't destroy opportunities for hardworking Americans. I look forward to hearing from our witnesses today to better understand the effects this proposal could have on our workforce. And so with that, I will now recognize the Senior Democratic member of the subcommittee, Representative Frederica Wilson, for her opening remarks.
Chairman, Wahlberg, thank you for holding this hearing today and giving us the opportunity to talk about the Department of Labor's proposed overtime rule. As a prelude to the passage of the Fair Labor Standards Act, President Roosevelt made a powerful declaration. All Americans deserve a fair day's pay for a fair day's work. This simple, powerful principle is the foundation of the historic labor law that we, as members of Workforce Protections Subcommittee, are charged with strengthening and defending. We must protect the workforce. Implicit in this principle is the freedom from excessive work hours. Explicit in FLSA is premium pay for overtime work. Overtime pay was established to protect workers from the excessive hours that endanger their health and well-being, prevent them from spending time with their families, and prohibit them from taking the necessary time to recover from the stresses of work, which we all need to do. Unfortunately, the failure to update the overtime salary threshold to reflect the economic realities of today has seriously eroded FLSA's protection against excessive hours and its implicit promise of a fair day's pay for a fair day's work. 40 years ago, nearly 2/3 of the workforce was eligible for overtime protections. Today, only 8% of workers are eligible for overtime protections. We cannot possibly argue that these current working conditions for millions of Americans are fair. It's not fair that the men and women teetering on the brink of poverty, people making $23,660 a year, are asked to work 50, 60, or 70 hours a week with no promise of extra pay. It's not fair that millions of mothers and fathers who are forced to work long hours each work find it almost impossible to give their children the time and attention they deserve, yet are still deprived of the overtime pay that could lend to the economic security of their families. It's not fair that a worker eager to advance her career can be enticed by the promise of a promotion, a salaried position with a management title, yet be met with astonishingly similar work duties, shockingly greater hours, and in the end, pitifully smaller pay. The Department of Labor's proposed rule promises to restore a fair day's pay for a fair day's work. The proposed rule would raise the salary threshold from the current $23,660 a year to about $50,440 a year, extending overtime protections to almost 5 million Americans. The rule also ensures that the salary threshold automatically increases to keep pace with future shifts in average earnings. These strengthened overtime protections would mean so much in the daily lives of millions of Americans. This overtime rule would allow more parents to be involved in their children's lives, something we know is absolutely critical for the development and betterment of our children. This overtime rule would encourage employees to hire more workers instead of overworking a few, meaning more jobs for more Americans. Jobs, jobs, jobs. The overtime rule would give part-time workers access to more hours that would help them earn more money. I stand strong with Chairman Scott and my colleagues on this committee in support of this overtime rule. I stand strong with the more than 150 House and Senate Democrats who sent a letter to President Obama this week to express our strong support of this overtime rule. I want to thank the witnesses for being here today and look forward to hearing about how this proposed rule strengthens overtime protections and renews the promise of a fair day's pay for a fair day's work. And I need to correct that. I stand strong with my ranking member and colleague, Mr. Scott. Thank you.
I thank the gentlelady. Pursuant to Committee Rule 7C, all subcommittee members will be permitted to submit written statements to be included in the permanent hearing record, and without objection, the hearing record will remain open for 14 days to allow statements, questions for the record, and other extraneous material referenced during the hearing to be submitted in the official hearing record. It's now my pleasure to introduce today's witnesses. First, Ms. Elizabeth Hayes is the Director of Human Resources at MHY Family Services in Mars, Pennsylvania. In her role as Director of Human Resources, she is responsible for overseeing all HR operations and regulatory areas, including those associated with benefits, administration, employee relations, health and safety, and policy administration. Welcome. Mr. Eric Williams is the Chief Operating Officer at CKE Restaurants Incorporated in Carpinteria, that better? California. Mr. Williams was named COO of CKE Restaurants in June 2015, having previously served as Executive Vice President of Operations for Carl's Jr. Mr. Williams began his career as a Hardee's crew member in 1983, advancing through the ranks with management positions in both the company and franchise operations and training. Welcome. Go Blue. Mr. Ross Eisenbray is Vice President and Economic Policy Institute here in Washington, D.C. Prior to joining EPI, he worked as a staff attorney and legislative director in the House of Representatives and as a committee counsel in the Senate. Mr. Eisenbray also served as policy director of the Occupational Safety and Health Administration from 1999 to 2001, and as a former commissioner of the Occupational Safety and Health Review Commission, and a graduate of University of Michigan Graduate School. Welcome. The Honorable Tammy D. McCutcheon is a principal with Littler Mendelson PC in Washington, D.C. She represents management clients in connection with all types of labor and employment matters, but focuses her practice on complying with the FLSA and state wage and hour laws, conducting audits of overtime exemption classifications, implementing compliance programs designed to avoid wage and hour disputes, and representing employers being investigated by DOL's Wage and Hour Division. Prior to her work at Littler, Ms. McCutcheon served as the administrator of the Wage and Hour Division at the Department of Labor from 2001 to 2004. Welcome. I'll now ask our witnesses, as is the custom in this committee, to stand and raise your right hand. Do you solemnly swear or affirm that your testimony you are about to give will be the truth, the whole truth, and nothing but the truth? You may be seated. Let the record reflect the witnesses answered in the affirmative, and we look forward to your testimonies. Before I recognize you to provide those testimonies, let me briefly remind you of the lighting system. Like the traffic lights, green is go for your 5 minutes of testimony. Yellow, caution, get ready to stop, start slowing down. Red, find a way to conclude as briefly as possible. We want to hear your testimonies, and we want to make sure we also have opportunities for questioning. And then, as our committee chairman is known to say, we will be a little bit more firm with our committee members. Right, Mr. Chairman, to keep ourselves at the 5-minute questioning timeline as well. And so, having said that, I now recognize Ms. Hayes for your opening 5 minutes of testimony.
Chairman Walberg, Ranking Member Wilson, and distinguished members of the subcommittee, my name is Elizabeth Hayes, and I'm the Human Resources Director at MHY Family Services in Mars, Pennsylvania. I've been in this role overseeing HR, operational and regulatory issues since 2007. I appear before you today on behalf of the Society for Human Resource Management, or SHRM. Thank you for the opportunity to testify today about how these proposed changes will impact not only my organization, but other employers. Mr. Chairman, quite literally, these proposed overtime regulations to more than double the salary threshold presents the risk of my organization closing its doors. As a nonprofit with tight costs, we are often unable to provide pay increases and hire additional employees. Worst case scenario, I estimate that these changes could result in additional and unfunded costs of more than $750,000. To be clear, this would be a 9.1% unfunded increase to our budget. Allow me to tell you a little bit about my organization. MHY is a nonprofit organization serving youth and families by providing support and services that afford opportunities for a better life. MHY offers comprehensive residential, educational, and community-based services responding to an array of hardships and traumas, including mental illness, behavioral issues, abuse, and neglect. Let me highlight some specific challenges my organization would face if these proposed overtime regulations are implemented. To be clear, most of MHY's exempt employees, managers, and professionals are currently paid less than $50,000, and under the administration's proposal would become eligible for overtime. As an underfunded nonprofit with limited flexibility in a budget, I have serious concerns about how we will cover potential overtime expenses while still providing high-quality services for the at-risk youth served by MHY. Our nonprofit's ability to provide critical services to the youth and families that we serve will be negatively impacted. At MHY, we prioritize a continuity of care model that ensures that the at-risk youth receive services and care from the same therapists and supervisors. Therapeutic services are driven by the relationships that our employees have with the youth and families to which they're assigned. Months and sometimes years go into building that trust and bond, and this can't be replicated by swapping in another professional to avoid exceeding 40 hours on the part of a primary professional. Under this overtime proposal, continuity of care would be undermined by limiting the ability of our employees to effectively respond to clients' clinical needs. Changes to the overtime regulations will likely require employers to reclassify a significant number of salaried employees to hourly employees. Hourly employees, of course, are paid only for the hours that they work and often are forced to closely track their hours to ensure compliance with overtime requirements. This can lead to less workplace flexibility. At MHY, our residential program managers, as an example, are provided with workplace flexibility options. If I had to reclassify these positions, they would lose their ability to leave early on calmer work days to watch their children's soccer game or take a Friday off for a long weekend, which they are currently afforded to offset long work hours on other days. Let me turn to some of SHRM's concerns with the proposed overtime rule at this point. SHRM appreciates the administration's interest in modernizing the FLSA overtime regulations and agrees that a measured salary threshold update is in fact warranted. However, more than doubling the salary threshold to the 40th percentile of weekly earnings presents challenges for employers like mine, whose salaries tend to be lower. The proposed increase to the 40th percentile sharply contrasts with historical updates to the salary threshold that represented more reasonable increases. Those increases acknowledge pay differences across sectors and in certain areas with lower costs of living. SHRM remains concerned that the Department of Labor may still make changes to the duties test that would further exacerbate an already complicated set of regulations for employers. Further changes to the primary duty test, including a required quantification of exempt time or the elimination of managers' ability to perform both exempt and non-exempt work concurrently, would create significant challenges for employers and employees. Should the DOL ultimately suggest changes to the duties test, SHRM believes a full comment period would be warranted. In closing, I can't overstate how concerned I am with these proposed changes on my organization's ability to fulfill its mission to serve the youth and families in Pennsylvania. In addition, I share SHRM's concerns that changes to the FLSA overtime regulations will disproportionately impact nonprofit organizations like MHY, employers in low cost of living areas, and employers in certain industries. Mr. Chairman, thank you again for allowing me to share my experiences and SHRM's views on the FLSA overtime regulations. I welcome your questions.
Thank you. I now recognize Mr. Williams for your 5 minutes of testimony.
Chairman Walberg, Ranking Member Wilson, and members of the subcommittee, thank you for the opportunity to testify today on the impact of the administration's proposed overtime regulations. My name is Eric Williams, and I serve as Chief Operating Officer at CKE Restaurants, the parent company of Carl's Jr. and Hardee's restaurant chains. Also own and operate 7 Hardee's franchise restaurants in and around Indianapolis, Indiana. CKE and its franchisees account for 75,000 jobs within the United States of America. Our employees are our greatest asset and are highly valued. As in my personal experience, our employees in our company can progress through our management ranks as high as their ambition may take them. Through hard work, determination, and the opportunities available in the quick service restaurant industry, I've been able to enjoy a long and fruitful career. The experience I received was very valuable. My hard work was rewarded with increased responsibility, greater pay, and opportunities to advance for a job well done. My career development was initially a slow process. I was promoted from crew to an hourly management position limited to 40 hours per week. Once I reached our weekly maximum, I was not allowed to work additional hours. I would have gladly traded the overtime premium to gain more experience and knowledge about the business. Shortly, I worked my way up to restaurant manager, where I was able to work a schedule that was most beneficial to the business and take off during the times that my supervision wasn't as needed. For example, local conventions provided significant business opportunities with significantly higher customer demands. Conversely, there were also a number of times when business was slow. During this time, I was able to spend additional time with my family, raise my 3 daughters, attend school functions, work with my church, and take vacations. As a salaried manager at a time-demanding location, I was able to earn a good living and still enjoy a good quality of life. Over time, my career accelerated, and I gained greater opportunities. During my time in middle management, I witnessed workers follow the same path to advancement that I followed, many of whom are still with our company today. Like myself, they have advanced in their careers and saved for the future by taking advantage of a model that encourages and rewards hard work. As I noted a moment ago, aside from now serving as CKE COO, I currently own and operate 7 Hardee's restaurants in Indianapolis. My restaurants create jobs for 160 people who live primarily in low-income urban areas. I offer entry-level management programs similar to the ones which provided me with the opportunities I had to advance within our company over the last 30 years. Without these programs and the labor guidelines that allowed for them, many talented young adults will be stuck in jobs focused on time spent on the clock rather than time well spent. They will not have the same opportunities I had because businesses just can't afford it. It will be both lucrative and fulfilling to the employees willing to invest the time and energy to move from hourly wage crew-level positions to salaried management positions with performance-based incentives. However, the Department of Labor's proposal replaces a general manager's incentive to get results with an incentive to clock more hours. The salaries of 4 of my 10 managers would be impacted by the proposal's change to the department's regulations. These 4 managers earn about $45,000 a year. Keep in mind that these salaries are competitive, particularly recognizing the regional economic differences across the country, and these managers are eligible for the previously mentioned performance bonuses and also receive generous fringe benefits. To comply with the department's proposal, these restaurants would take an estimated 6% reduction to the already thin margins that exist in the restaurant industry. The additional overtime cost is likely to negatively impact the rest of our hard-working workforce by reducing hours, reducing salaries, or reducing bonuses and equity incentives. I would be forced to eliminate 3 salaried assistant manager positions and put them back on the clock. I can assure you that a demotion is the last thing these employees want, since it would block their career path to general manager. I would be forced to limit their hours to 40 hours per week and to schedule them on the busier shifts, which would allow for little development to grow their careers. As for CKE-owned restaurants, under the new rule, we would need to rethink how we staff and schedule our management employees. Overtime pay is a penalty employers pay for requiring employees to work extended hours. It does not increase productivity, nor does it increase revenue. It simply requires employers to pay time and a half for routine work, which reduces earnings. This is why we manage overtime very closely. Rather than staff our restaurants with salaried managers with performance-based bonuses who can earn higher pay, we would be forced to operate the business with fewer managers who would be paid less due to a reduction in hours and bonus, and who would be limited to a 40-hour work week. Unfortunately, operating with fewer management positions would limit the advancement of crew employees into these positions and stifle their personal growth. As a personal example, I was promoted from a crew position to a management position because there was a position available. And this opened many doors for me. Reducing the availability of those positions because they are too expensive hurts the very people we're attempting to help. Should the rule prevail, it is highly doubtful that we would expand our staffing much beyond current levels, primarily due to the rising costs of recruiting, training, and providing benefits to new employees. We would first look for ways to increase the existing employee productivity at the current wage, eliminate non-essential tasks altogether, and use technology to reduce hourly positions. While we may find the need to increase our minimum staffing levels to maintain high levels of guest service, we would primarily utilize part-time employees for limited shifts during the busiest hours of our operations. It should be clear that the biggest cost will be to all the talented people who, like me, could have advanced from cook to COO or franchise owner. Finally, I have heard that people are concerned that to avoid paying overtime, employers are calling employees managers who are just stocking shelves. However, in reality, stocking shelves or engaging in similar activities won't make you a manager and won't exempt you from the overtime requirements under federal law. Managers may well help their employees stock shelves or perform other physical work while performing their primary duty as a manager, which is hardly something to disdain. Each manager is entitled to decide whether to perform such tasks, such as the small business owners may decide to perform non-managerial physical work to increase their profits or to show the crew that they too can perform these tasks. As anyone who's run a business knows, that's what effective owners and managers do. Mr. Chairman, Ms. Wilson, subcommittee members, thank you, and I'm happy to answer any questions.
Thank you. Mr. Eisenberry, I recognize you for your 5 minutes.
Thank you, Mr. Chairman and members of the committee. I'll make 5 points and then I'll elaborate on them. First, America's middle class has suffered through decades of wage stagnation and rising inequality that can't be corrected without changes in a range of federal policies that have worked against them. 2, the department's higher salary threshold for exemption from overtime will help. It's long overdue, and millions of struggling middle-class workers will benefit from closing this loophole, which lets employers work them long hours without pay. 3, the rule will raise wages for some employees, reduce excessive work hours for others, and create hundreds of thousands of jobs. No one paid less than $50,000 a year should work more than 40 hours a week without being paid for it. For the overtime law to be effective, the salary threshold for exemption must be indexed so it increases automatically without political intervention. Automatic indexing is well within the Department of Labor's authority. Many employers, unfortunately, have gotten used to a system that lets them work people long hours without paying them for it. But that is exactly what the FLSA was intended to prevent. Employers will adjust to this rule as they did to the original Fair Labor Standards Act and every improvement in the law and the regulations since then. What seems like a big increase in the salary threshold is simply the result of employers having gotten used to a loophole in the law for far too long. So number one, from 1979 to 2013, inflation-adjusted wages in the United States rose only 15.2% for the bottom 90%, less than 0.5% per year, while wages for the top 1% increased 137%. The economy and total national income grew, but most Americans were left out. Tax policy encouraged CEOs and top executives to grab an oversized share of income, and they have. CEO pay for the 350 largest corporations grew 1,000% since 1978, while the pay of average workers increased only 11%. Corporations have relentlessly squeezed labor costs at the expense of average workers, increasing profits and benefiting shareholders and executives with stock options. Corporate profits are at all-time highs, while tens of millions of workers struggle to get by. The decades-long push to cut labor costs has gone too far, and the economy is out of balance. Too many families have too little income because their wages have been held down. They can't spend what they aren't paid, and they can't be the consumers that businesses need. It isn't inevitable economic forces, but rather federal policies that have reduced employee bargaining power, encouraged excessive executive compensation, worsened inequality, lowered labor standards, and offshored jobs. Those policies should all be reversed. Overtime reform is one part of the solution. Number two, the current salary threshold, the level above which employers can refuse to pay for overtime work, is less than the poverty line for a family of four and doesn't begin to reflect the status and financial reward that characterize true executives, administrators, or professionals. The small group that Congress originally meant to exempt. None of your constituents thinks an employee paid $24,000 a year as a bona fide executive. The current rule is indefensible. The regulatory changes in 2004 did double harm. They inappropriately expanded the exemptions and set the salary threshold at a level so low as to be a joke. In 1979, the salary threshold covered and protected about 12 million employees. Today, it protects only 3.5 million, even though U.S. employment is 50% greater today. Number three, on job creation, Goldman Sachs, EPI, the National Retail Federation, and the Department of Labor all agree. The rule will create more than 120,000 jobs, provide wage increases for some employees, and reduce excessive work hours for others. Those jobs are needed. Millions of Americans are unemployed, and experience here and abroad tells us that the affected employees and their families will be better off. Number four, to prevent the kind of neglect that led to a 29-year decline in the real value of the threshold for exemption, followed by another 11-year decline, it has to be indexed, preferably to the growth in compensation of salaried employees. The department has for decades failed to carry out its statutory mandate to update the rules in a timely way, and indexing is the only way to prevent that kind of failure in the future. Nothing in the Fair Labor Standards Act or any subsequent enactment limits the department's authority to index the salary level. Finally, five, some employers have made it their business model to work salaried employees not 40 hours a week, but 60 to 90 hours a week while paying them salaries too low to meet a basic family budget. I've talked to and written to them, and I've seen scores of stories in the comments we collected on the rule, including the stories of employees worked literally until they dropped from injury or disability. Fran Rogers, who for many years had a hugely successful consulting business that worked with corporations on improving work-life balance, put it well in a New York Times op-ed. Employers, like all of us, tend to be careless with and waste what they don't have to pay for, including the precious time of their time-stressed employees. The rule will make employers less careless and more efficient by making them pay for overtime. They'll adapt. What seems like a big increase in the salary threshold is simply the result of employers having gotten a free ride for too long.
Thank you. I now recognize the Honorable Tammy McCutcheon for your 5 minutes of testimony.
Thank you, Mr. Chairman. I'd like to spend my time today talking about the salary level based on my experience of being at the Department of Labor during the last set of changes to these regulations in 2004. Since the early 1940s, the DOL has consistently stated that the purpose of setting the minimum salary threshold for these exemptions is to provide a ready method of screening out the obviously non-exempt employees. This is not a minimum wage for exempt employees. In fact, exempt employees are exempt from the minimum wage and the overtime requirements. DOL's proposal of $50,000 salary level does the opposite of screening out the obviously non-exempt, and instead excludes from the exemption many employees that are obviously performing exempt duties, and in fact many hundreds and thousands of employees that the DOL itself and federal courts have found perform exempt duties. I want to be clear, there is no at the U.S. Chamber of Commerce, who I'm representing today, there's no one in the business who is claiming that it's not time for a salary increase. From 1938, when the FLSA was passed, to 1975, the salary level was increased every 5 to 9 years. It has now been 11 years since the last increase in 2004. So it is time for a change. The question is how high? And the Department of Labor's proposal of using the 40th percentile of all salaried earners to get to that $50,000 is just unprecedented in the regulatory history of in the 77 years of the FLSA. In 1948, for example, 1958, in setting the salary level, DOL looked at the 10th percentile of employees and the salaries earned by exempt employees in lower wage businesses, lower wage geographic areas, and in small businesses. In 2004, we adopted that 1958 methodology, doubled it, and we looked at the bottom 20th percentile of salaried earners in the South and in retail, where wages and cost of living are lower. The Department of Labor proposes to set the salary level at the 40th percentile, but not looking only at rural areas, small businesses, and lower profit margin businesses. They're using a data set that includes all salaried employees. It also includes doctors, lawyers, sales employees, and federal employees, who all, of course, earn a lot more than most exempt employees, and by the way, are not even subject to the salary level tests in the regulations. This 50,000 level, I guess the best way to demonstrate how high it really is that it is actually higher than the salary levels that are required for exemption under New York law and California law. Just like the minimum wage, states have their own exemptions from overtime and can set their own salary levels. In New York, that salary level is around $34,000 a year, and in California, employees who are earning more than $37,000 a year can be classified as exempt from overtime. That number is going to be going up to $41,000 in 2016. So the Department of Labor's proposal is $10,000, $15,000 higher than the minimum salary level for exemption in New York and California, arguably the two highest cost of living states and higher salary states. This is like applying the San Francisco $12.25 minimum wage in Biloxi, Mississippi. It just won't work and will have a disproportionate impact on economies in our rural areas, and particularly in the South and in the Midwest. If you go back through and the historical salary levels from 1938 to the present and correct those numbers for inflation, also the 50,000 level is simply not supported. I actually used the BLS inflation calculator to create the chart that's in my written testimony. And what that shows is that if you correct for inflation, all the salary levels under all tests over all the entire 77-year history, the average is about 42,000. So 50,000 is at least $10,000 higher than any possible justification that you could have. Before my time expires, I also want to talk briefly about the duties tests. The Department of Labor has not proposed any specific regulatory changes to the text of the duties tests. However, they have also stated in an email in response to a question from the publication Law 360 that they do not have to propose specific statutory regulatory text in order to make significant changes to the duties test. In their opinion, all you have to do under the Administrative Procedures Act is to propose issues for discussion. I'd like to suggest that words matter in statutes and in regulations. A comma placed one place versus the other can really make a difference about how that interpretation is, how the regulation is interpreted by DOL or the courts. Yet, if there are changes, if DOL goes through with making significant changes in the duties test, for example, adopting the California rule on primary duty that employers have to establish employees spend more than 50% of their time performing exempt duties, we will not have an opportunity to actually review and comment on the statutory text. And in my opinion, that is not in the spirit of the Administrative Procedures Act and given the public a sufficient time and a meaningful role in the regulatory process. Finally, I do want to talk about the impact. You've heard about that from some of the other increases. There are advantages and disadvantages to being classified as exempt. Exempt work, and the biggest advantage for being exempt is you have a guaranteed salary, a salary that cannot be reduced because of the quality of your work or the quantity of your work. An exempt worker who works even an hour during a work week must be paid their entire salary. This is where the flexibility comes in. As an exempt worker, you can go home early. I have heard Secretary Perez himself talk about how important it has been in his life to have jobs that gave him the flexibility to attend his son's sporting events. With this regulation, with potentially 5 million employees being reclassified, you are taking that flexibility, which is so important, away from those 5,000 workers. Instead, as a non-exempt employee, you just get paid for the hours you actually worked. So if you need to take time off to go to a PTA meeting, you really have to think, can I afford this, because I'm not going to be paid for these hours that I'm taking off. The other differences between exempt and non-exempt that I'd ask you to consider is, and I think we heard Mr. Williams talk about this, availability for bonuses and incentive pay. Non-exempt employees generally do not get the opportunity to earn bonuses and incentive pay, because if you pay those bonuses, you also have to pay overtime on the bonuses. That calculation is complex. It's easy to make mistakes, and if you make a mistake, you could face massive liabilities.
I'm going to have to start paying you overtime here soon, so
I'm sorry.
I think there'll be plenty of time for questions on this, and you're a walking textbook, as each of our witnesses are. So, having said that, I'll now recognize for first round of questioning, or the first 5 minutes of questioning, Mr. Bishop of Michigan.
Thank you very much, Mr. Chairman. And thank you to the panel. Thank you for your time. This is a very important issue. We appreciate your testimony. I know it's frustrating to have only 5 minutes to say what you want to say. This is an important subject, and we'd like to hear more from you. One of the biggest concerns that I get from my constituents and the businesses that I represent as I travel across my district is the growing administrative burden, the costs of these new regulations that have been descending upon small business in particular for quite some time. And it's becoming more and more stifling to the point where many businesses feel like they have an entire wing of their business whose sole purpose is to deal with regulation and compliance. And it is really choking off small business. It's a big issue, and it's one that I think a lot of us are going to spend some time to find a solution for. But I'm told that the department has estimated that this particular regulation in the first year alone is expected to cost $600 million, which to me seems unbelievable. And I am interested in hearing from all of you, of course, and I wish that I could, but in particular, I'd like to hear from Mr. Williams. Sir, you bring incredible perspective to this, given the fact that you were an employee, a middle manager, and now the COO of a major American business. And I'm very interested to hear your perspective on this. You've seen it. You're inclined to want to do whatever you can to enhance the employment environment in this country, to advance the economy. Do you view this as a positive change? What would the administrative, any negative impacts that this might have? Business such as yours, and is this are there many unintended consequences that we're seeing today that can be avoided? How can we better address this issue? I know you had a lot of testimony. I know you heard through it. I'd like to hear more.
To avoid that. Now, in my own business in Indianapolis, I have 4 managers that are assistant managers, that are managers that are below the proposed rate. And those managers, I'll have to move those salaries up to the proposed rate. And there are 3 managers that are below the proposed rate that I will have to put them back on the clock. This will be a very demoralizing effect, which is an unintended consequence to that this regulation will bring. When I first took over that business, one of the things that I saw in some of those employees was the potential to be general managers, the potential to be but they were being held back because we had to limit their hours to 40 hours. Businesses
that businesses like yours would be less inclined to hire, would be less inclined to advance their employees to a management level. And in fact, it has an effect of negatively contracting your business so that you are less likely to grow and be more prosperous.
That is correct. Under the guidelines now, we would staff a restaurant with additional management personnel. Those management personnel that are not the restaurant manager, they have an opportunity to grow. And so you would have maybe a couple of managers on the shift that would all supervise an area, or they would all supervise employees. Under this guideline, those managers, we would not be able to afford those managers, and so we would have less management positions available. So the manager position that I advanced into would no longer exist because we just simply couldn't afford it. So yes, it would have a contracting effect, and ultimately could not only reduce the earnings of a business, but it could have an impact on guest service and sales because there's less supervision available to manage the business.
The gentleman's time has expired. I now recognize the gentlelady from Florida, Ranking Member Ms. Wilson.
Thank you, Mr. Chair. My question is for Mr. Eisenbright. According to the Economic Policy Institute, in 1975, nearly 2/3 of salaried workers were eligible for overtime pay. Now, only 8% of salaried workers are eligible. What effect has this shift had on wages and on the average number of hours worked? Would you elaborate?
Well, it's not clear overall what it's had on the number of hours worked. If you look at the BLS surveys, I think that they show fairly steady weekly hours. But if you look at Gallup polls and public policy opinion polls, the general survey, general social survey, they all are showing that salaried workers are working longer hours. The average being in some of these surveys as much as 49 hours a week. So I would say there's no question. Everyone at the table would agree that salaried workers who don't have to be paid overtime will work longer hours than people for whom overtime has to be paid. That's what Mr. Williams just said. So the effect of exempting people obviously is to increase their hours. And when they don't get paid anything more for it, all it does is increase the stress in their lives without compensation.
In your testimony, you mentioned the woman named Dawn Hughes. You say retail store managers like Dawn Hughes, who was paid a salary of less than $35,000 a year, are sometimes forced to work as many as 90 hours a week. You go on to say that a salary and a title are no protections against oppressive overwork and never have been. Is that story an isolated one? Is this something that happens often? If so, why don't the workers just refuse to work all those extra hours?
Well, workers can't refuse to work the extra hours because they'll be fired by their employer, the corporation that employs them, whether it's Dollar General or Dwayne Reed, whoever it is. We've heard stories from dozens, scores of workers who say that they, at very low pay, when you make $35,000 a year and you work 60 hours a week, your pay is reduced to about $12 an hour. When you work, as Dawn Huey did, 90 hours a week, your pay actually falls to below the minimum wage. And she had no life at all because she was working all the time for the corporation that employed her until she was finally injured, until she was basically worn out and couldn't work any longer. But that is not an isolated story, and I'd be happy to share stories that we've received in the comments with the committee.
Can you go on to discuss why overtime protections are even necessary for salaried workers? If workers are making a salary instead of hourly wages, why should they be entitled to overtime?
Well, they have always been entitled to overtime under the Fair Labor Standards Act. We didn't have a 40-hour work week in America until the New Deal, when President Roosevelt and the Congress passed this law. And people who had been working 50 and 60 hours a week suddenly had a standard work week of 40 hours. The fact that they were salaried, the stories in the department's reports of white-collar workers being paid $17 a week and working 60 hours are the very reason that we had the Fair Labor Standards Act. You can be a blue-collar worker, a carpenter, making $60,000 a year, and your hourly wage will be 150% when you work more than 40 hours in a week. A salaried worker making $25,000 a year, who's held to be exempt under the rule as it is now, gets nothing for the extra 20 hours a week. Nothing, zero. Not time and a half, not straight time, not 1 penny.
How did the Department of Labor come up with the proposed salary threshold?
Well, they went through the long history of the Act and looked at all the different possibilities. Ken McCutcheon mentioned one that the department has used. In 2004, they did something different from what had ever been done before. So there's no set rule in the statute about how the department approaches this. I think that they chose the 40th percentile because it's of salaried workers, because they understand that the rule is meant to exempt a small number of top people, the bosses, the people who can control their own time. It was never intended to be something that exempted low-level accountants and people in, the clerks in insurance companies, first-line supervisors. All of those people were intended by the law to be covered.
Gentlelady's time has expired. Now I recognize for 5 minutes of questioning Mr. Klein, Chairman of Ed and Workforce Committee.
Thank you, Mr. Chairman, for the courtesy of recognizing me for questions and for holding this hearing. Ms. McCutcheon, it's good to see you again. Welcome back. There seems to be a difference of opinion here that at least I'm hearing between Mr. Eisenbray's view of the 40th percent threshold and percentile and yours. And you were making a point, Ms. McCutcheon, in your testimony about how this is unprecedented to go to the 40 number instead of 10th and 20th percentile, which has been more normal. And you started to say, in fact, you had about 1 sentence worth or so in here as you were comparing New York and California, but I think you picked Biloxi, but we could pick a whole lot of other places. Can you take a minute or two here and talk about what that difference means, the difference in economies, the difference between rural America and places like San Francisco and Manhattan?
Certainly. It does make a difference because in 2004, we looked at salary levels in the rural Midwest and the rural South. We looked at salary levels in different industries. And I guess the best way to put it is where I grew up in the Quad Cities, Illinois, Moline, Illinois, Davenport, Iowa, you can buy a house for less than it costs you to park a car in New York City, right? And so a $50,000 salary level in some place like Indianapolis, Indiana, for example, is a very, very good living because a salary, and it's among the top of the salaries in that area because of the low cost of living. And so trying to apply something that, yes, maybe $50,000 works, well, I was going to say maybe it would work in California, but not even California thinks $50,000 would work in California since their level is $37,000. So I'm not sure where this works outside of San Francisco and New York City themselves, but what it does is it's just not in line with local economies and the realities of local economies, and that's what DOL has always tried to do, is to look at the actual salary levels that are reflected, to draw that line between, to exclude only the obviously non-exempt. And if you think about, for example, your own staff who are earning less than $50,000, from the duties they perform, there's going to be a lot of them that are not obviously performing non-exempt duties, even though they earn below $50,000 a year.
Yeah, thank you. It concerns me, we're always worried about a one-size-fits-all. And in this case, you were talking about what the purpose was. Mr. Eisenberry has said this is to affect the boss's boss kind of thing, and you were making the point that no, that was never what this was really designed to do, to go back from the very beginning. And so you were talking about where you looked and where to set that bar based on what seems to be a different criteria than what we had heard about. Can you just touch on that again? You had it in your testimony, but I want to get that clear.
Well, the salary is not the only test for exemption, right? Employees who are paid by the hour who earn below the minimum salary level must be paid overtime. But if you earn more, you still have to meet the duties tests, which are quite substantial, right? And that is why the purpose is to drawing the line is to exclude the obviously non-exempt. The employees who, just based on their salary alone, are unlikely in the department's view to ever be able to meet the duties tests. And so it is not about, this is not a minimum wage debate, right? And so this is not about increasing and cutting off, getting rid of wage stagnation is not the goal here. The goal is to have rules that will allow at least some bright line judgments in the Department of Labor's eyes about who earns a salary that's low enough that they're obviously non-exempt, even if the duties tests are applied.
And then once you get past that obvious line, then you're going to get into the duties test, which we haven't yet seen in this thing.
Which
And
we
that's
don't really know.
Which
what
we
the
don't know
changes are
yet.
gonna be.
Right, exactly. Okay, thank you very much. I yield back, Mr. Chairman.
I thank the gentleman, and now I recognize the gentleman from Virginia, ranking member of the full committee, Mr. Scott.
Thank you, Mr. Chairman. Ms. McCutcheon, you mentioned someone who would be entitled to their salary even if they worked 1 hour a week. Is it your testimony that somebody showing up 1 hour a week can expect to receive their salary on any kind of ongoing basis? Is that your testimony?
Yeah, that's called the salary basis test. That's a third test for exemption, and what the salary basis test is.
Well, I just ask you, if somebody's showing up 1 hour a week, it's your
Yes.
testimony that
If
they can
they
keep
are
their job,
exempt.
that they could keep their job?
Well, I've done it, and I haven't lost my job.
Okay.
yet.
Well, we've just received the testimony as it's given. Mrs. Hayes, most people think of full-time work as 40 hours a week. How often do you require employees to work more than 40 hours?
The need to work 40 hours or more than 40 hours a week would be dependent on what's transpiring in the course of delivery of services. We don't mandate that our exempt employees work any specific number of hours, but we do have children very often who are in crisis during the course of any given day or night.
Right, and when you ask them to work more than 40 hours, what compensation do they get for the hours after 40?
For exempt employees, they don't receive additional cash compensation. They can flex their schedules.
Okay,
however.
now, if they don't get any compensation over 40, is there any limit to the number of hours you can ask someone to work for no compensation, no additional compensation?
We don't assign a limit, but MHY is committed to something called self-care as part of a sanctuary model. We preach regularly the need to balance work and life as part of a model of treatment and care that takes into consideration both the safety and needs of clients as well as our employees.
Well, Mr. Eisenberry, if someone is required to work more than 40 hours a week, what, in most cases, when the employer says, we need you to work 50 hours this week, what happens if they don't show up?
Well, there's no prescription against mandatory overtime, and that employee could be fired.
Okay, now let's go through a couple of scenarios. Somebody's making $10 an hour, and they work 40 hours a week. If they were to work a few extra hours, how would they be compensated for those extra hours?
Well, if they're hourly, they'd be paid time and a half, 150% of their regular rate. If they were salaried, they wouldn't be paid anything more.
If they were salaried under the threshold?
If they were salaried under the threshold, then they would not be exempt. They would be entitled to overtime.
So if somebody making $10 an hour, about full-time, $20,000 a year, they would get time and a half?
They would, yes.
Okay. Now, if somebody's making $15 an hour and they work the additional more than 40 hours, they're paid $15 an hour on an hourly rate, they would get overtime,
Yes.
time and a half. Now, if you converted that to $30,000 a year, what kind of compensation would they get for the extra hours?
If they were hourly,
Now, if you called it 30,000, if you called it 30,000 a year salary,
if they were in an exempt position, they wouldn't get, they'd have no right to any overtime pay at all.
any right to overtime pay or any extra pay at all?
Any pay beyond the 30,000.
So if you're making $15 an hour, you got time and a half over 40. If you're making essentially the same $30,000, if you call it $30,000 a year, then you not only don't get the right to overtime time and a half, you don't get any extra salary at all.
You don't have the right to a penny for the extra hours, that's right.
Can you say a word about how the new rule will reduce litigation involving overtime?
Well, in 2004, the rule was put out and with the promise that it would reduce litigation, and since then, litigation has tripled. So I think changing the duties tests as they did led to a lot of litigation. This rule, by contrast, as it's been proposed, is as simple as it could be. It just tells an employer, if you pay a salary less than $50,440 a year, the person is entitled to overtime pay. I mean, that could not be clearer, and it will affect about 15 million people who otherwise might be subject to litigation because they don't know whether and their employers aren't sure whether they're exempt or not.
The gentleman's time has expired. I now continue with the state of Virginia and recognize Mr. Bratt for his 5 minutes of questioning.
Thank you, Mr. Chairman. I think it's, first of all, important to note that I think everyone in the room here has the same goal. We'd all like people to be richer and do better and have happier lives with the family and the kids. The only problem with this proposal, and it's important to look at this proposal, everyone's nibbling around the edges, right, about certain groups of people and certain kind of moves around in the short run, around wage rates and pay and hours and this kind of thing. I think it's important to go back to the long run to show that this kind of procedure at the macro level, these kind of policies will fail, right? And so in the long run, I made a very high-tech graph here, it's just a straight line going up. In the long run, your wage rate is roughly speaking the same thing as your productivity, and there's no cheating that. We would all like to just announce to the world that everyone can make $500 an hour, et cetera. So just do that thought experiment. Any students out there? Let's just pay everyone $500 an hour. Is that possible? No, it's not possible. Everyone knows that because wages have to track productivity. Right. And so instead of dealing with the underlying issue that matters in this country, enhancing productivity, we try to do an end run with clever little procedures that in the short run may enhance wage rates or hours worked, and that's a little wrinkle in this nice line. But over the last 200 years, economies that don't focus in countries, our country has had phases of time where we let Rome rule, right? The central planners up here, and we don't do as well as a country. And so at a time where we should all be talking about productivity growth, because that's the only thing that gives the next generation of kids a good life, we're still doing this little nickel and diamond around the edges. And so as my colleague brought up before, when we go around door to door and talk to the vast number of small businesses and the CEOs in the room and the folks that are speaking on the economy, we hear the opposite is going on. Instead of enhancing productivity, we find small business talking about the regulatory burden. I think for the country as a whole, it's about $1.5 trillion per employee. I think it's $10,500 per employee in regulatory costs that go on to every small business. We have the Affordable Care Act. Obamacare is crushing small business and making it harder to pay people. The EPA overreach, regulatory burden, et cetera. And what we're missing in some of the testimony, we started hearing hints at what's really going to happen. What's really going to happen in the short run, too, is people are going to get fired. And we don't pay attention to them. They're off. They're not in the labor force anymore. Right? So we don't look at them. The people are going to lose their jobs. Firms are going to substitute capital for people. and hire more little smart screens instead of people. And so it's nice to have all these clever little ideas in mind, but in the long run, the bottom line is any country that over the long run tries to run their economy from Rome and from central government land is no longer a nation, right? And you have the perfect case study with Greece going on right now, right? They've moved in this direction. I think the youth unemployment rate's 50%, right? Youth out there. If you want 50% unemployment rate for the youth, go towards centralized planning. And so I just question for Mr. Williams or the Honorable McCutcheon, can you comment in the business world on how we can be more effective at enhancing and getting to this goal by increasing productivity and just what we can do to really make progress, because I think we all have that goal in mind. And Mr. Williams, if you want to lead off.
With respect to productivity, and I've heard the testimony of some of the other witnesses that talk about 90 hours and 100 hours. In those scenarios, that's very low productivity. And even as being a manager myself for years and years and years, I've investigated those kinds of comments and those kinds of claims. And what we find is very low productivity, if not some embellishment in terms of what that person is really doing with their time. So yes, I would agree with you that the low productivity will be enhanced because an individual will now just ride the clock. If I have an opportunity to enhance my pay by working 50 or 60 hours, then that becomes my bonus, and I enhance my pay that way. The manager that is salaried, that realizes what the goals are of his job, now becomes the more productive manager, because they recognize that I'm going to get paid my salary whether I work 30 hours or whether I work 40 hours. I think the thing that we've missed here is that, and I think one of the questions was, would I expect to get a check for 1 hour? Yes, and I've gotten a check for 1 hour before. I come in, I count inventory, I leave, and I go home. And that was my job for that day, and that was my job for that week, and I did it, and I got paid. So I was very productive with that, and I'll yield the rest of my time to.
The gentleman's time has expired, and you really are a professor, aren't you? Yeah. Thank you. Now I recognize the gentleman from Wisconsin, Mr. Pocan.
Sure. Thank you, Mr. Chairman. Well, you know what? I'll pick up on that, on the productivity question, because here's the number I'm looking at. Since 1973, productivity has gone up 74%. The hourly compensation for a typical worker in the same period has gone up 9%. The average CEO pay during that same period, 937%. Something doesn't quite add up on all those numbers when you look at that. And then I'm looking at this rule, and specifically the fact that only 8% of the people are currently, covered under this area, and we're trying to get to the 40 percentile, when in the past we've been up to 62 percentile back in 1975. I'm a small business owner. I have been since I had hair. Since I was 23 years old, I've run a small business, and I'll tell you, I just look at it differently. I look at my employees as my partners, not as a line on my budget. And unfortunately, this conversation so seems like we're talking about employees as simply a line on the budget, as some end-sum game. I think, Ms. McCutcheon, you made a comment about the benefit of having a guaranteed salary. You know what you're going to make no matter what your productivity is. Kind of doesn't work in the real world. I don't know if you've ever had a small business and had employees where this ever affected you, but it's not a benefit to know you're only going to make so much even if you work 60 or 70 hours a week. And quite honestly, if someone's not productive, we're not keeping them on anyway. We're not keeping someone on if they're not productive just because we have the benefit of giving them this salary. And then we talked about how they're less likely if they're non-exempt to get a bonus. That's not true either in the real world. I think people still can get bonuses in a lot of different business structures. There's no rule that says you don't have to. You're saying simply because they'll pay overtime on it, but maybe they should be paying overtime instead of having their employee work for free after making 24 grand. So here's the question I have. Since we brought up Biloxi and we brought up San Francisco, if you're making $23,660, that's take home before tax, $1,971 a month. The median rent in this country, according to Zillow, I looked it up, is $1,350 a month. Can anyone make a strong case how that makes sense? $1,971 a month. Overtime, you're not going to get any extra pay, but the median rent is $1,350 before your utilities, before any kind of car, before any kind of cable, food, entertainment, etc. You want to talk about San Francisco? Even under that new dollar amount they're coming into in 16, they're going to now be having $34.16 a month. You're right, it is different parts of the country, but that median rent is $3,055. It's still lopsided. The worker gets screwed over every time, no matter how you do it. Let's go to Biloxi, all right? Biloxi, you're right. It is lower cost of living, but you know what? In Biloxi, that median rent is $813, 40% of your gross salary. So the problem we're having is we need to talk about how you affect a real employee, real wages, so you've got a productive employee. And quite honestly, keeping them at poverty level or making them work for extra hours for free and not being able to even get by much past the rent doesn't make any economic sense. So let me ask a question, Mr. Eisenberry. One of the things that's come up over and over and over is this benefit that you can take a Friday off or leave work an hour early after you've worked 60 hours a week under this scenario. What's the real benefit to this flexibility for an employee? Because I still look at it, if they're working 60 hours a week, that's 1,000 extra hours a year they're not getting paid for that you don't see your family, so you can get that Friday off. To me, I don't see the cost-benefit ratio, but if you could share a little bit from your research.
Well, we did a report on this. Lonnie Golden, a professor at Pennsylvania State University, used the General Social Survey to see what happens in terms of flexibility, asking employees who are salaried and hourly who make less than $50,000. Actually, the survey asked between about 25 and 50, so it was perfect for this rule. And he found that you're actually somewhat more likely as an hourly employee to be able to take off an hour or two during the day than a salaried worker. It's not common that anyone can do that. Salaried workers don't generally have that right, but there was actually no more flexibility in that range. Once you get up to a real executive salary, to Tammy McCutcheon's or my salaries, then people start to have the ability to actually take the time off. But
Sure.
it's not
Real quick, I have very little time left. Ms. McCutcheon, a quick question. Do you think 150% is the right number? Should it be higher, lower? What kind of number should we have at that rate?
I want to make clear, I'm in agreement that it's time for a salary level
Yeah,
increase.
my question, though, is on the 150%. If you could very quickly, I'm on the yellow
On
light, the only
overtime,
reason I'm asking.
Time and a half has been the way it's been in the FLSA.
So you don't have a problem with that?
No.
Okay. Thank you. I yield my time back.
Thank the gentleman. I recognize now for 5 minutes questioning the gentleman from Pennsylvania, Mr. Thompson.
Thank you, Chairman. Appreciate the opportunity for this hearing. Ms. Hayes, I want to say welcome as a fellow Keystone State person. I wanted to welcome you to the hearing and also thank you for your role in providing critical support services, at-risk youth, all the things that that your agency does. Having worked, well, as I like to say, when I had a real job, it was really a lot of that time was spent working with nonprofits, and recognize that the workforce that we need, is based on the level of the types of services they're providing, the intensity, and it's cyclical sometimes, and having that flexibility. So my question, flexibility in terms of how do we deploy that workforce as well, so that it works well for the employee and quite frankly fulfilling the mission. And so I really do have a vast appreciation for nonprofit organizations and their admirable missions. And given your experience overseeing such an organization, can you elaborate on how the administration's overtime proposal will impact nonprofit employees and their relationships with those that they're serving to be able to fulfill that mission?
I think one of the biggest concerns that we have is around continuity of care. With an increase like that, which we're discussing today, it would be a priority to be able to move individuals around who are professionals, therapists as an example, to avoid overtime costs. Again, unfunded overtime costs. In terms of continuity of care, you spent a very long, as I said in my testimony, developing relationships with the clients that we serve, with their families, with the caseworkers that we work with within the counties. There's a lot of time dedicated to developing those relationships and that rapport and that trust, notably with the clients first and foremost. You can't just switch out therapists to offset time worked, to avoid additional overtime costs. it diminishes continuity of care. There's not the same level of communication with those clients as with the primary caregiver, with the primary support services. That would be a significant concern for us. For MHY, it would be paramount to control significantly who are now exempt professionals and managers, the amount of time that they're putting in to handle crisis, to support staff who are handling crisis, and again, to provide direct care services both on our residential campus as well as out in the community services field, where we have several therapists who have a great deal of autonomy in when they meet clients, when they meet with schools, social workers, case workers, the families, get them all together. There would be a great deal of controls on that, and another level of bandwidth that we can't afford to administer that.
Very good, thank you. Ms. McClutchan, the Department of Labor proposes to automatically increase the salary threshold annually based on either the 40th percentile of salaries or inflation, which would lead to rapid increases in the threshold. As your testimony points out, Department of Labor has repeatedly rejected automatic increases due to concerns regarding the impact on certain regions and industries. What problem do you see in automatically increasing the salary threshold? Was it Congress's intent in the law for the salary threshold to increase automatically?
I question whether it was Congress's intent. Congress itself has often rejected proposals to index the federal minimum wage for annual increases in inflation. And in 1996, when Congress enacted the exemption for computer employees at an hourly rate, they did not increase that, have any indexing of that hourly rate for inflation. And the problem with using the 40th percentile is it's going to have a ratcheting effect. Like in 2006, as employers increase some people's salary in order to get them over that 40 percentile level, that means the next time you look at the data set, it's going to be higher salaries. And so the 40% level keeps moving up and moving up, ratcheting in geometric levels until there's virtually no non-exempt people who qualify for this exemption. And contrary to Mr. Eisenberg, this exemption has been in the FLSA since 1938. It's always been the largest exemptions. There's actually over 50 exemptions in the FLSA, partial or total, from the overtime and minimum wage requirements. So I don't see any evidence that it was ever intended to be a tiny exemption.
Yeah. Thank you, Chairman.
Gentleman's time has expired, and I now recognize the gentlelady from Ohio, Ms. Fudge.
Thank you very much, Mr. Chairman. I thank you all for your testimony today. I guess maybe I'm one of the few people that really lives in the real world here. Hiring is based on need. People hire people because they need them. They don't hire them out of the goodness of their heart. And so if you don't need a person, you don't hire them. You're making it seem to me that you are doing them a favor by hiring them and then making them work a lot of hours and not paying them. That's not how this business works. It's supply and demand. That's just basic, simple economics. Mr. Eisenberg, is there any data that you're aware of that supports the premise that higher wages causes job loss?
No, I think that one of the big problems with our economy right now is that wages have been held down so long that the power of consumers has been reduced, and therefore businesses are not hiring. They don't have the customers they need. And that's what every survey of small business says, by the way, that the problem is not regulations. That's not the first thing that they say. Their first problem is we don't have the customers we need.
Thank you very much. And so Mr. Williams' premise that overtime pay is a penalty, and I believe I wrote down exactly what you said, is actually not accurate, is it?
Well, in a sense, he's right. It's a penalty on employers who work their employees excessive hours.
That's what I thought.
It makes it more expensive for them to do that.
Thank you. Mr. Williams, you say you have about 75,000 employees. First, let me congratulate you for working your way up. I think that that's the American dream. I appreciate that. I started working at McDonald's. I understand the process. You have 75,000 employees. Approximately how many of them are management employees?
It would probably be about 30%.
The microphone.
So 30% of your employees are management employees. You don't mind paying the other 70% overtime, correct?
That is correct. If
Okay.
they work over 40 hours, they get time and a half.
And so what is the responsibility of a manager, just a regular line manager? What are their duties as a general rule?
Exempt or non-exempt.
Exempt.
Well, exempt manager has to pass the duties test. And so they would have to be a bona fide executive. They would have to have the responsibility of hiring and firing. They would have to be the person that manages the business according to the duties test of the Department of Labor.
Okay. So basically, you have very trusted employees, people that do a great job, just as you do with your people that work with your children. And I think that that's a great thing, that you have people that you trust, that you believe in, that you trust with the lives of kids, but you guys don't want to pay them. That's what I don't understand. You have these valued employees in which you have put a lot of time and a lot of money, a lot of energy, you trust them, and then you want to restrict their pay when you make them work 60, 70 hours a week. It just doesn't seem to mesh to me that you value your employees if you don't want to pay them.
Ms. Fudge, may I just correct the record on something?
Yes.
It has been said that this is the biggest increase, that we've ever had in the salary threshold. I just want the record to reflect that it's been 11 years since the last increase. From 1938 to 1949 was 11 years, and the increase in the salary threshold for administrative employees went from $30 to $75 a week, which was 150%. So that is not true, and I think that we need to keep it in perspective.
Thank you. At least I very much appreciate Ms. McCutcheon talking about the fact that it is time for a wage increase. I appreciate that, because it is. The very people that you all represent, low-income people, they're the ones who need it the most. I appreciate that you hire young people in communities of need, but they are the people who need the increases more than anyone else. So yes, you're helping them in one respect, but you're holding them down in another. So I just want to thank all of you for your testimony. I am hopeful that as we go forward, we can find some way to come together to try to help the people that all of us, I believe, want to help. Mr. Chairman, I yield back.
I thank the gentlelady. I now recognize the gentleman from Indiana, Mr. Akita.
Thank you, Chairman. I appreciate you holding this hearing. I appreciate the witness's testimony. Mr. Williams, I appreciate you operating a business in Indiana, where I'm from. I thank you for what you do in the community and the experience you give employees at various different levels. Some of them whom have it's a first-time job experience, some have a part-time job experience, so that they can offer better lives for themselves and their families, which I think is part of the American way. First off, do you have any further response to my colleague Ms. Fudge's comments, or anything that she said, anything you want to add for the record?
Well, I just want to make sure that I want to, tie two thoughts together. One, the thought on productivity. More productive managers get better results, and so that's ultimately how you measure whether or not a person is productive. What did you get done? And to say that a more productive manager, or a person that works more hours, that we don't want to pay them, just really isn't reality.
Right, because for one thing, they can go somewhere else, right?
With
the experience that you gave them, that they learned from you, they can walk right away, and there's a cost to that, isn't there?
Absolutely. And businesses over time have recognized the value of their employees, like our business. We recognize the value of the employees. And so what businesses have done to reward employees, that particularly salaried employees, is they put performance incentives together, so that employee, that more productive employee, has an opportunity to actually earn more money than they would by logging additional hours. And that's the incentive process that we have in place, both at the company I own and CKE that we manage, and it's common throughout the industry.
Right, well, thank you for that. I associate with Ms. Fudge when she says, this is not done out of the goodness of hearts, or there's businesses to be run and all these kind of things, and she mentioned supply and demand. I think that's exactly right. It's another way that I describe the free market, and that you can freely go to another job or something, or not, or stay, and have that kind of relationship with your employer. The 90-hour example, where this worker was seemingly forced to work 90 hours and not compensated for, I want Ms. Hayes, you and Mr. Williams, you to comment on that. I'll switch over to Ms. Hayes for a minute. In your experience, have you ever met someone who worked 90 hours like that and was so productive that couldn't get a job somewhere else if they wanted to? Or can you comment on this whole situation? It seems odd to me.
Short answer is no.
Can you is your mic on? Yeah.
Forgive me. The short answer is no. You know, if folks are working 90 hours a week in an exempt capacity, there certainly are alternatives if an employer is not recognizing that, either by way of compensation or flex time or some other method that would offset the balance of that. Frankly, I think the folks that we have who work probably the most hours in any given week are, in fact, our direct care staff who earn time and a half.
Oh, yeah, so you're either compensated for it,
Correct.
you know, or
That's correct.
you have some other
Right.
avenue. Mr. Williams, anything to add there?
I agree with Ms. Hayes that the managers that work more hours generally are not as productive. And generally, if you have a manager that's working that many hours, it's generally a crisis situation and it's very isolated.
So there's a productivity situation.
So there's a productivity issue.
Certainly, if you want to have that kind of lifestyle and you can be productive, you would either be compensated for it appropriately or you'd soon be somewhere else.
Well, yeah,
for a more appreciative employer.
Your results would demonstrate that productivity and would be rewarded by the benefits that you have achieved within the business, whether it be bonus or additional flex time or employees that are developed to take your place, those sorts of things.
And again, the simple law of supply and demand that Ms. Fudge rightly points out handles this.
Absolutely.
Everything you're describing right now.
Absolutely. I would agree with that.
Ms. Hayes, the President's March 2013 memorandum to the Secretary of Labor directed him to, quote, simplify the regulations to make them easier for both workers and businesses to understand and apply, unquote. As an HR professional, do you think this rule succeeds in simplifying the FLSA's overtime regulations, or do you see this rulemaking as really a missed opportunity to help employers comply with the law?
We don't generally have a great deal of difficulty with the overtime regulation in that respect as it relates to the memorandum. We're managing it fine. We're a very flat organization. Nonprofits tend to be so. So, you know, there isn't a lot of creative interpretation that we have to manage to assign exempt versus non-exempt status.
Okay, thank you. My time's expired, Mr. Chairman.
I thank the gentleman. I recognize the gentlelady from Oregon, Ms. Bonamici.
Thank you very much, Mr. Chairman, and thank you, Ranking Member, for allowing me to participate, even though I do not serve on the subcommittee, but I'm on the full committee, and this is an important issue. Thank you to all of our witnesses for being here today. And this hearing's about the administration's proposal to update overtime rules, and it's going to be important to actually hear from the Department of Labor about the proposed rule and why it's needed, and I look forward to those conversations. But I'm glad we're having this discussion today. I want to I'm a big picture person, and I want to point out the issue as I see it. People are working hard. Too many people are working hard and barely making ends meet. They're worried about whether they can save for their kids to go to college, retirement security, whether their children will do better than they did. I mean, that's everybody's dream, that you know, their kids will be able to do better. People are worried about that now because there are too many families that are just barely making ends meet, even when they're working full time. So it's important that we have this discussion not only about overtime, but also about other workplace policies that have not kept up with our changing workforce, things like fair scheduling practices, paid sick leave. You know, hourly workers often face unpredictable and irregular work schedules, and in many cases they have very little say about the dates and the times that they work. We've heard about employees getting to work and then being told that they're not needed, but they've cleared their day and then they don't get compensation for that. This all adds to the challenges that working families have trying to balance their responsibilities at home and at work. I'm proud to be a co-sponsor of the Schedules That Work Act that give workers more of a say in scheduling and provide more predictability in scheduling practices and certainty and financial security for families. I want to note that there have been advances in technology that really make that feasible now, more so than it has been in the past. My home state of Oregon has been a leader. Legislature just passed a comprehensive paid sick leave law that allows workers to earn sick time that can be used not only for their own but for immediate family's illness, preventive care in instances of domestic violence. I mean, those are important policies. We don't want people coming to work sick. We don't want people stressed out and sending their sick kids to school. Family-friendly policies like this actually help businesses recruit and retain. They have good, loyal employees, and it decreases turnover and the costs associated with that. There was a young man in Oregon who told a quick story. He said he's in high school, in the 12th grade. He said, I live with my mom and 3 siblings. Whenever one of my siblings gets sick, I have to stay home and take care of them because my mom has to go to work to provide us with what we need. He said, it's my last year in high school, and having to skip school and stay home to take care of siblings affects me. I need to complete all my homework and projects. I want my mom to be allowed to have paid sick days so I can complete all my work as a student. Now, that's just an example about the need for our updated policies. That kind of situation is unacceptable. Paid sick leave will help his family and others like theirs, just like the overtime proposal will help working families across the country. It's past time that we update the rule to keep pace with our changing economy, our changing workforce. Mr. Eisenbray, I wanted to ask you to discuss what you see as the effect of this rule on workers' hours and wages. Now, there was a suggestion in some of the testimony that workers may be reclassified from salaried to hourly, and then as a result, see their pay reduced if they need to take time off, for example, if they're not in a place where they have paid sick leave. Or if they want to attend a school function with their child, for example. Do you see this rule being used to actually change salaried employees to hourly, and then they may lose pay because they need to take time off?
All of the studies that I've seen so far, the National Retail Federation, Goldman Sachs, the Department of Labor's analysis, and our own, suggest that employers will respond to this in different ways. You know, Mr. Pocan, as a small business person, would just give the people overtime pay who are earning less than the threshold. Other employers will, as Mr. Williams said, probably convert some of their people to hourly, people who were salaried, and when those people now work overtime, if they do, they'll be paid time and a half. People who are close to the salary threshold will have their salaries raised. So if you're making $48,000 a year and the threshold is $50,000, an employer, it will be in the employer's interest to raise your salary to be above the threshold so they can continue to work you overtime hours without time and a half pay. It is certainly the case, all of the studies suggest that employers will convert some salaried people to hourly. That they will shift, most importantly, they'll shift hours from people who are currently managers, let's say working 20 hours a week extra. If they had to pay time and a half to them, they will say, no, I'll switch those hours to new people, to part-timers, to people who are on my payroll now working reduced hours. The hours will be shifted to them. Shifted to them. The Goldman Sachs suggests 120,000 jobs will be created through that process. The Retail Federation said over 110,000 jobs just in their sector, and they're only 20% of American employment. So you can imagine that, and the Department of Labor is closer to Goldman Sachs, but I think hundreds of thousands of jobs are likely to be created.
The gentlelady's time has expired. Appreciate it. I now recognize the gentlelady from New York, Ms. Stefanik.
Thank you, Mr. Chairman. I yield my time to you, Chairman Wahlberg.
Oh, thank you. I certainly can use it. Let me continue on with that statement by Mr. Eisenbray. Mr. Williams, it's indicated Goldman Sachs and others indicate increased jobs. Does that bear out in your life experience that this change in rule on overtime rules would increase jobs in your business? And how would it if it does?
Well, it could increase lower level jobs at the
Lower pay, lower level
paid,
jobs.
lower level jobs, yes.
With less opportunity?
With less opportunity, because after the 20 hours that was mentioned, it has to pass through the test of, is there anything in those 20 hours that we can get rid of? Is there anything in those 20 hours that we can outsource? Is there anything in those 20 hours that we can move to employees to make them more productive by eliminating those same things out of their jobs? So after you pass through that test, then what's left might be those lower part-time jobs at the lower pay scale.
Ms. Hayes, would you concur?
I would absolutely.
With your employees?
Yeah, I would absolutely concur with that. You know, the trick to this is that either way, in the nonprofit sector, notably in the human services sector, we have to be afforded increased funding to support additional jobs, be they manager-level positions in one case, or as Mr. Williams is discussing, the frontline positions. You know, most human services organizations, and ourselves, MHY included, don't have that luxury. We can't just add positions. We can barely fill the positions that we have right now.
Mm-hmm.
So, but you know, they would be frontline jobs by and large to relieve managers of anything that we could in their job responsibilities.
Could this impact on MHY's mission of promoting safety, health, education, spiritual well-being of the youth and families under your care?
Yeah, significantly so around safety. One of the things that our managers and supervisors are so good at is, and what their experience brings to the table, is when we have crisis situations with our kids. Their leadership, their experience, their education, their training helps to de-escalate those situations a great deal. Now certainly our staff are trained in those areas as well, but they don't have the experience that a manager line does. Diminishing their ability to stick around on really dicey days to help manage new admissions and the emotions and the behaviors that come with that, or a bad family visit in which kids could spend the rest of the evening in an escalated state and be very unsafe to themselves, to the other clients on the unit, or to the staff, really is enhanced by a manager's presence. So safety would be a significant concern.
And Mr. Williams, you mentioned ambition rewarded. In your experience, as well as those people that you've had the opportunity to manage and move up along the chain, how does this impact on ambition rewarded, or I guess I would say ambition frustrated?
The reduction in the number of management persons, as Ms. Hayes said, creates a vacuum. So in other words, you would not have those management positions available for those who are ambitious and want to see their careers rise. They would have to wait until those other positions were vacant, and by that time they may find other employment or may find something else to do. But the ability to accelerate through an organization would be stifled as a result of that, because you just couldn't afford it.
Thank you, and I yield back my time. And the gentlelady's time's expired. Thank you. I now recognize Mr. Russell, the gentleman from Oklahoma.
Thank you, Mr. Chairman, and thank you for your testimony here today. It is a very important issue. As a small business owner, I find myself in not having flexibility for people that could be salaried, to give them the opportunity to work for a mission, to get something accomplished, and then later be compensated for time which they consider valuable, to take care of their families or their needs. Many times these labor laws that we cite as protecting the worker, I would argue, many times put business owners in a difficult position because they cannot give the workers the flexibility that they need in a modern age. Mr. Eisenbree, I would like to ask you a few questions. Does salary make a person more efficient or less on the job as opposed to workers with overtime?
I don't think it really makes a difference that a worker will be as productive as you know, his or her desire and skills.
So, but you contend here in your testimony that salaried workers are being unfairly compensated because they work more hours than if they were on some hourly wage with overtime. Is that correct?
Absolutely.
Okay, well, with that in view, do you think working long hours on a set salary is unfair? And if so, do you think it makes the business more effective and workers more effective, or does it make them less effective?
Well, you know, the stories that I've heard from people like Dawn Huey are that they worked 90 hours a week sometimes, and there's nothing good about that. I mean, the store was productive, but her life was ruined by it.
So nothing good about it, and you said in your testimony that government should use every tool at its disposal to help America's working class. Do you realize that every uniformed worker in the military is salaried? So their life just must be miserable. And that organization must be very inefficient because it is filled with salaried workers. Is that your contention?
It is not my contention.
Well, then why do you think that the president, who has not provided raises to our military, in fact, the numbers that you cite are really greater than what the president has provided in raises to the military when he is asking them for all kinds of missions that we send across the globe and new missions that are unfunded with the dollars that we have at hand, and yet he has even threatened that he will veto the National Defense Authorization, which calls for raise for these salaried workers. Well, if you think that the president's initiative is so good, then how do you account that he doesn't care about the salaried workers that he can control?
I don't think that that's true. I think, I don't know all of the details of the budget negotiations, but they probably involve, a compromise that one side now wants to break and have more money for defense and not more money for the enforcement of environmental regulations and health and welfare and education. I imagine that that's what's going on. And if the president had the ability to increase the budget and increase taxes to pay for it, he would give salary raises.
He has that ability. In fact, when you look at the cost of free cell phones and the cost of his free internet proposal and the cost of so many, why, that could be put directly into the wages of privates and our seamen and airmen that are out there on the front lines. But yet, he thinks that these entitlements are far more important. And what I would offer to you is that salaried worker in a company that they take pride in, such as Carl's Jr. or Hardee's, or something where they have a path to work their way up, or they enjoy it. I served 21 years in the military. I didn't get rich off of that. I moved 15 times in 21 years and raised 5 kids in uniform. That's not a way to the rich house, I can assure you. But there wasn't a time that I didn't take pride in my job. And I was a salaried worker. And as a commander, a 90-hour work week, I would have welcomed that. I would have welcomed that. And so what I offer to you is you need to take a step back and look at that the salaried workers are not out there to punish employees. They're not out there to somehow make their life draconian and exact slave labor and sweat and blood out of these workers. It's giving them opportunities to grow. And I'm sure we have illustrations and testimonies today where people started as a fry cook and ended up as franchise owners and highly successful people. And so I tend to disagree with the whole premise of your testimony today on salary workers. And with that, Mr. Chairman, I yield back my time.
I thank the gentleman with a little fear and trepidation. I mentioned the commander's time has expired. But, thank you. I now recognize myself, since I am a non-exempt, for my 5 minutes of questioning. And I appreciate the witnesses being here today. Let me ask Ms. McCutcheon, just to think through your background experience, your understanding of the issue a bit, and dream a little bit. How would you structure the duties test for the 21st century workplace, and Also, speak to what suspicions you might have concerning the Department of Labor's intentions on the duties test subsequent to their questioning.
Thank you. I think we did a pretty good job in 2004, and I think we heard today from one of the witnesses.
Is your mic on, or maybe closer? Yes.
I mean, move it closer. I think we did a pretty good job when we updated the duties test in 2004. And I have heard from my own clients, and we've heard from the witnesses today, that employers are able to apply those rules. The concern is that if we have another major change to the duties test, we'll see even more litigation as employers adjust and try to apply new ones. In particular, concern is the executive exemption, where the Department of Labor has suggested that they might adopt a California rule to require 50% of an exempt employee's time to be spent only in exempt work, which is not the realities of the workplace today. We're not in a 1930s industrial economy where you have union work and non-union work. We have exempt employees who, for employee morale and to make sure the businesses are running effectively, pitch in and do non-exempt work. And you shouldn't use the exemption when you walk to the copy machine and do your own photocopies rather than asking your secretary to do it. So those types of changes, I think, would be very concerning and not reflect the modern workplace if there are changes. I am concerned that we have not seen any regulatory language. In 2004, when we did our comments, we would take out a word here and there that we thought were not, didn't add any meaning. We would drop a comma for grammatical purposes. And in the comments, what we heard was, no, dropping that word is significant. You can't drop it. Moving the comma is significant. You need to put it back in. And because DOL has not given us any regulatory text to react to, we cannot be meaningfully engaged.
Give us a little more example on what that comma might mean.
Right. It could, well, or an and. If you change a word from or to and, that is significant. And since we're not going to be able to see the regulatory text before the final rule, there's the process, the rulemaking process won't function like it should in giving the public an opportunity to tell the Department of Labor that they've moved they shouldn't have changed it to and or they've moved the comma inappropriately.
Ms. Hayes, you mentioned in your opening comments in your testimony that scary phrase, this could put us out of business. Could it?
I'm going to go
or is that hyperbole?
No, I'm going to go back to my testimony and use the words quite literally. We have approximately 50 employees who fall into an exempt status that would be affected by this regulation change. Professionals, therapists largely, and managers. To deliver services to the extent that we're obligated to and contracted to, at the rate of which we're funded, with this imposition on our ability to deliver those services and be required to restrict so that we could stick to a budget that's, again, already underfunded, is almost an impossibility. These therapists and these managers need to have the ability to deliver services in a manner in which we're obligated per regulation and in compliance with requirements from third-party insurers to Department of Human Services. So, it's going to be very difficult for an organization like MHY to make good on its commitments, its continuity of care obligation, without going over those 40 hours for people who are making $40,000, $45,000, $50,000 a year. We're borrowing from our foundation right now just to keep the lights on.
So we're talking here about not only potential loss of employment, but significant loss of service to people who need it or who aren't connected with overtime issues or duties issues, but simply need the care that you receive.
We serve approximately 1,000 clients a year in our education program, our residential program, and our community services program. We employ, like I said, if we're fully employed, we employ about 160 people. More realistically, we employ about 140 jobs in Mars, PA.
Well, thank you. My time has expired, and I appreciate so much the questioning of my subcommittee, as well as the answers, the comments that have been made all across the spectrum today. And it's an important issue. We take it seriously here. And so now I'll recognize the ranking member for her closing comments.
Chairman Wahlberg, I want to thank you again for holding this hearing and giving us an opportunity to discuss the Department of Labor's proposed overtime rule. I want to thank the witnesses for being here today. And every time we have these hearings, I want to remind my colleagues that what we discuss during these hearings affects the lives of working people in our districts. These proposed overtime rules will truly change the lives of millions of Americans and make good on the promise of a fair day's pay for a fair day's work. This proposed rule will mean more mothers and fathers will have time to care for their children and be involved in their lives. Think what that will mean for the next generation of children, for them to have their parents home just a little more, to help them with their homework, teach them to throw a baseball, to give them the discipline, the supervision, the support, and the love they need to grow into strong, smart citizens. This proposed overtime rule will mean more American workers will find a new job because employers will be encouraged to hire more workers instead of overworking a few. It will mean more part-time workers will find more hours as employers spread around hours. Think what that will mean for our economy if more workers had jobs and more money to spend. Think what it will mean for our country if we get one step closer to guaranteeing a fair day's pay for a fair day's work for all Americans. This overtime rule is for the millions who struggle under the circumstances we have heard discussed today, who work excessive hours with no extra pay, who are tormented by the impossible choice of keeping the job with absurdly long hours or being unable to provide for their families. For all those who are trying as hard as possible to make ends meet and to get ahead, this proposed overtime rule is for you. We are the Workforce Protection Subcommittee. Our job is to protect the workers who are the workforce. And I want you to know that the Democrats on the Workforce and Education Committee, more than 150 Democratic members of Congress, with many advocates and organizations represented here today, will fearlessly and fervently fight to defend this much-needed update to overtime protections. We will fight to ensure that this proposed overtime rule reclaims the fairness owed to millions of American workers. We will not only fight for this rule, but fiercely defend against attempts to erode any existing overtime protections. We will fight against efforts to strip workers of their overtime pay that takes the insidious form of comp time. Allowing employers to give workers paid time off or comp time in lieu of overtime may sound great, but for the fact that it is the employer who gets to choose when and if the employee can take that time off. Bills like this amount to more work and less pay for families who are struggling to make ends meet because comp time can't pay the bills, buy bread, or help build our economy. Mr. Chairman, I ask unanimous consent that letters from the following organizations be entered into the hearing record: the Center for American Progress, the Center for Economic and Policy Research, the National Employment Law Project, the National Partnership for Women and Families, the United Steel Workers 9 to 5. These letters express support for the Department of Labor's proposed rule to increase the overtime salary threshold. Thank you, Mr. Chairman.
I thank the gentlelady, and these letters have already been received and part of our record. Well, again, thank you for this hearing. Thank you for the input that you all put in. In closing, I would just say that we as well are committed to making the workplace of the 21st century something that is growing and expanding of opportunity. I'm not going to use the words that we'll fight for it. I want to work with all sectors and both sides of the aisle as well to make sure that we have a workplace that is expanding and growing for opportunity, with opportunity for people. That we have certainly ambition rewarded and not frustrated. That we have a workplace that encourages people with all aspects of their life. But understanding the realities, that means we must work together. We can't have a one-size-fits-all plan. That won't work. It doesn't work in my marriage, I can tell you that. It doesn't work with my kids or grandkids. We have to have the flexibility that moves us forward. The duties test. I would hope that the Department of Labor would give us a stronger indication. In fact, I would hope and will be making strong suggestion and request that they extend the time of implementation, that they take time to listen to what was said here today and read the information put in our other hearings as well, and look to the reality of what's going on. 60, 70 hours without overtime is a vast overstatement if you just take in the context that was pushed out today in so many ways, and I hope without intention. But that's the rarity. That's not every week. But it deals with the realities of what the workplace entails. With an economy that's been very sluggish, with a work growth economy that's been very sluggish, and is aimed toward low income, minimum wage, and not the living wage that we want to see take place as a result of the growing economy that's done by government getting out of the way as much as possible and letting the grassroots grow what can and has grown in this country in the past. Employers will adjust. A statement was made here today in testimony. Yes, employers will adjust. We know that. That happens. But how will they adjust? Will they adjust by expanding opportunity for more people to grow and find their sweet spot? No, they'll adjust to meet the needs of staying alive and viable. And that doesn't always work in the best way. And so then the next question ought to come, will employees adjust? Be much more difficult for them if they don't have the job, if they don't have the opportunity to expand. And so I promise to my ranking member, as well as my committee and all in the room, that we will work toward finding a solution and encouraging the Department of Labor to take a second look at a solution that is not a one-size-fits-all, that doesn't go beyond the reality of the workplace and the workforce in the world today and in this country, and to make sure it fits. And we move forward, but we move forward in a way that doesn't break, but rather expands opportunity. We'll talk about this in the future, I'm sure, and we look forward to that. Having no further business to come before this subcommittee, it is adjourned.